first part. We're just going to give it a few more minutes and let some more people join, hopefully, and then we'll get started. Okay, it is noon, so we are going to go ahead and get started. And then if anybody joins late, hopefully in the next few minutes, they'll be able to catch back in. Okay, from the Ohio Chamber, thank you everyone for joining us today. We're really excited to put this one on. It's a great topic, a really important topic, so we're happy to have you here. I'm going to pass it off to Christina here to take over and start presenting for us.
Sure. Hi, everybody. Thanks for joining. It's great to be back. My name is Christina Nero. I'm a partner at Franz Ward in our labor and employment group. I'm a management side defense attorney. I'm an OSHA defense attorney as well. I appreciate that this might not be at the top of everyone's priority list, but as Megan said, an important topic all the same. I'm going to get ready to show my screen here and just make sure that everybody can see that. And we'll get started here. So, COVID happened, and, we've all had a bunch of other fires to put out in the last 18 months to 2 years. And so I thought it would be a good opportunity to just do a really quick refresher on harassment law before we dive in. 3 main ways in Ohio that your employees can bring a sex harassment claim. Of course, under the Federal Civil Rights Act under Title VII, sex harassment, which is a form of sex discrimination, prohibits discrimination in all phases of employment, from start of employment through the application process and recruiting, all the way through termination. So that's at the federal level. Ohio has its own state Civil Rights Act that similarly prohibits discrimination based on sex and employment, which includes sexual harassment. And then Ohio has a common law claim for employers who aren't quite big enough to fit under either Title VII or the Ohio Civil Rights Act employee thresholds. There's a common law claim that employees complete as well. 2 kinds of harassment, as we well remember. Quid pro quo, translated in Latin, I'll give you this if you give me that. This is, submission to a sexual advance being used as a basis for an employment decision, whether that's good or bad, whether it's being used to advance someone improperly or retaliate against someone improperly when rejection of that sexual advance is communicated. This one, we don't see that often, although we know that it does still happen. But this one has a higher legal standard for employers to overcome. It's strict liability to employers if you can demonstrate this kind of quid pro quo sex harassment. The one we hear more about, of course, and definitely hear these buzzwords more, is the hostile work environment claim. This is a claim, where there's conduct based on gender that basically interferes with your work environment. It creates an intimidating, hostile, or offensive work environment. And courts are going to do a fact-specific analysis, generally speaking, based on these three considerations: whether the conduct was unwelcome, whether the conduct was offensive, and whether the conduct was pervasive. And there are a combination of objective and subjective perspectives that the court takes, but the court will look at these three factors from the perspective of the alleged victim and from the perspective of a reasonable third person. What would a reasonable third person under the same circumstances have felt in that same situation? So we're here today to talk about, Me Too and sex harassment and how that has affected the workplace, both pre-COVID and post-COVID. So, I want to take everybody back to the year 2017, which was only 4 years ago. It feels like a lot longer. But when you say it, in actual numbers, not that much time has passed since all of these high-profile allegations started happening and the media started first reporting on, for example, the Harvey Weinstein scandal, followed by several other high-profile men. And of course, since that news broke, there have been hundreds of other high-profile cases. And of course, as we know, the publicity surrounding these sexual harassment allegations sparked a social media movement, #MeToo, and then that kind of spurred also into a corollary Time's Up movement. So these, are a few examples of the origins, I guess, the most recent origins of the Me Too movement. The Me Too movement really started back in 2016, but this is when it hit mainstream media about 4 years ago. And there have been several effects of the Me Too movement that we saw pre-COVID and that we're continuing to see: legislative, culturally, and then, of course, in our judiciary and our court system. So starting first with our legislatures, what new laws were passed as a result of the Me Too movement? The big one that has kind of had the most success in the most states has been legislative action to mandate sexual harassment training in employment. And you can see here the list of the few states where the legislatures have gone ahead and passed laws, each of them a little bit different. Some of them saying it's mandatory training if you've got 3 or more employees or 5 or more employees. Some more conservative saying, okay, well, you're not really going to be able to handle this unless you've got 50 or more employees, so we're going to make the cutoff 50 or more employees. Each of them a little bit different too with respect to what the training has to include. Connecticut, for example, says the training has to be a minimum of 2 hours. The training has to allow for a question and answer session. The training has to be conducted in a classroom-like setting. So each of the requirements for the training itself different across each of these states. Some other states have gone not quite that far, but have come out and said it might not be mandatory. We're not going to force you to do it, but we do strongly encourage you as employers, private employers in our states, to conduct annual sexual harassment training, Ohio being one of them. And you can see the couple of other states, Michigan too, that borders a couple of the other more kind of, I won't say middle of the road, but perhaps not on either end of the ideological spectrum. Another legislative effect in these states that you can see here is the banning of non-disclosure agreements, sometimes known as confidentiality agreements, in sex harassment cases. So in cases where there are settlements had between companies and individuals, former employees or current employees who've alleged sexual harassment, these states have banned confidentiality provisions in those agreements. There has been some federal action. It was limited. Obviously, you can see here it's pre-COVID. It hasn't really gone anywhere since COVID, but at least preliminary steps being taken at a federal level, probably not going to go very far. Although if there is any hope for it, it would be in the current administration. Massachusetts and Rhode Island, two other more progressive states that are still working on it, that might be added to that list of states in the near future here. We don't really think of taxes in the context of changes that have been significant, but this one has been significant to employers who are settling these kinds of cases, whether they are pre-litigation or they're in the middle of litigation. Under the tax laws in our country, employers can deduct their ordinary business expenses, which include legal fees and settlement amounts. The change that happened in December of 2017, however, as a result of the Me Too movement, is that now if you're settling a sex harassment case, you have to choose. Do you want to take the business deduction, or do you want the agreement to contain a non-disclosure or a confidentiality provision? So now employers can't do both. You have to choose whether you want to keep the terms of the agreement confidential, or if you want to take the business expense as a tax deduction. So that can be significant, particularly if you're in high stakes litigation. You're talking about hundreds of thousands of dollars of legal fees. This can be a tough decision. And unfortunately, still, 4 years later, we don't really have guidance from the IRS to know if we're doing a general release of all claims, whether this particular provision will apply if it's not specific to sex harassment claims. So until there's more guidance from the IRS, just consider costs and benefits of including confidentiality in your settlement agreements. Another legislative, perhaps less pervasive effect of Me Too has been in a couple of states and cities, expanding sex harassment prohibitions beyond those who are your W-2 employees. Federal sex harassment law and most state laws as well, they only apply to employees. They don't apply to independent contractors. And likely they're laws that are going to be applying to employers who have probably 15, 20 or more employees. Independent contractors, people working for smaller companies, don't necessarily have the same legal resource if they're harassed on a job. So at least in New York, California, and New York City, non-employees can now also bring claims against you as a private employer. Obviously, lots of cultural effects too that have happened as a result of the Me Too movement. I'm showing you a chart from the EEOC, which is the federal administrative body that kind of screens sex harassment claims if they want to be filed in federal court under Title VII. And you can see from the chart this drastic increase, right, from 2017 when the media started reporting on these high-profile cases over the years. 14% increase in charges year to year from 2017 to 2018. Obviously, awareness being raised about the issue, women feeling empowered and feeling like they have a voice. These are also statistics from the EEOC, so this doesn't even include private litigation or arbitrations or anything like that. These are just settlements made through the EEOC, even though the way that EEOC charges on sex harassment claims had not changed. The amount of monetary benefits being paid in those types of cases, as you can see, went up drastically year to year. The purpose of the Me Too movement was to bring the issue to light and to, in some ways, publicly shame and publicly shame wrongdoers. The idea being, if we publicly shame, we'll deter such conduct from happening in the future. But there were some unintended consequences that came along with the Me Too movement. I'm showing you a survey here from 2018. 3 questions taken from a multiple survey question. But these I found to be the most compelling, and especially the first one, right? 41% of men in general, more reluctant to have one-on-one meetings with women with no others present now that the Me Too movement has come about. And you can see, same statistics roughly for 2019, still a large percentage of women, of men reluctant to either interact with or outright hire women in the workplace. So a movement that was supposed to be empowering women has now, in some ways had the unintentional effect of holding women back in the workplace, and in some ways creating a new form of sex discrimination, men treating women differently and perhaps not providing them with the same employment opportunities in one-on-one meetings for mentoring and business development and so on that they would have before the Me Too movement. Judicially, which is kind of my wheelhouse, there have been some interesting judicial effects as well. I'm now seeing more defamation claims than I used to before the Me Too movement, on both sides, I have to say. Men using defamation lawsuits against their accusers, and in some cases the media, who have reported that these male individuals have engaged in sexual harassment or sexual misconduct. But on the flip side too, women suing their accusers after perhaps their statute of limitations has expired on sexual misconduct claims. So from both sides, and I included a couple of photos as examples. Geoffrey Rush won more than $500,000 after he sued an Australian newspaper that had accused him of sexual misconduct. Johnny Depp, on the reverse side, suing his ex-wife Amber Heard, who had accused him of domestic abuse. Ashley Judd, her statute of limitations having passed, ended up suing Harvey Weinstein after his studio described her as a nightmare to work with. This is, of course, after she came out publicly with allegations of sexual harassment and sexual assault against Harvey Weinstein. And then obviously Bill Cosby, his representatives accused almost 10 women, I think, of lying about their sexual assault claims against Bill Cosby. They filed a lawsuit, a defamation lawsuit, and ultimately settled that with his insurance company recently. So defamation kind of coming back into vogue. And I've just put up on the screen here a general definition of defamation, which is a false statement that's published to a third party that causes harm. Ohio has a little bit of a broader take on defamation, but two kinds of defamation: libel if it's written or published, slander obviously if it's spoken. So something else to keep aware of. And just some statistics, because I think statistics demonstrate really in a way that explanation can't. I talked to you about, a derivative of Me Too being the Time's Up movement. And there was a legal defense fund that was established in the wake of these things in order to help women accusing high-profile men of sexual misconduct who perhaps could not afford to take on, the high costs of pursuing these lawsuits. 1 in 5, 33 out of 193 cases that were funded through this Time's Up Legal Defense Fund involved defending employees who came forward about sex harassment and were then sued on the other end for defamation. Judicially, too, we're seeing a lot of activity, I'll say, courts considering whether to actually enforce confidentiality or non-disclosure provisions in these kinds of sex harassment settlement agreements. Pre-Me Too movement, courts really only would invalidate these non-disclosure agreements in egregious circumstances on really strong public policy grounds. Now, post-Me Too, courts being more willing to analyze whether they're going to continue to enforce these, viewing, these confidentiality provisions as overly coercive, and as a tool used to silence victims of sex harassment. I've got two photos up here. One of former Trump campaign staffer Jessica Denson, who's sued for sex harassment, and then separately sued to void the non-disclosure agreement that she signed while working for the Trump campaign. And then obviously we've heard a lot about the silence breakers, the members of the U.S. gymnastics team who breached the terms of the non-confidentiality agreement purposefully and publicly, but were not pursued judicially for breaching their confidentiality provisions. So we have this huge buildup of the Me Too movement, in the 2.5 years after the Harvey Weinstein scandal. And, a lot of people are probably thinking, COVID hits and the pandemic starts, people are working from home. This not only fades to the back of our minds because there are so many fires to put out, as I said, with COVID, but people are probably thinking, well, you're working from home. There aren't a lot of in-person interactions taking place in the workplace, really even socially for a period of time there. But in reality, as I'm going to show you on these next couple of slides, workplace harassment actually didn't go anywhere. Research suggests that it perhaps morphed. At worst, we'll see some statistics that show that it actually increased in severity as a result of COVID. Here are statistics from the EEOC's 2020 reporting year. You can see on the bottom there, sex harassment claims didn't go anywhere. In fact, they generally increased. And we're talking too about technology-based harassment taking the place of physical and in-person or more traditional, what we would think of as traditional harassment. Two surveys that I'm going to talk to you about today that indicate that remote work might have actually made it unintentionally easier for colleagues to harass their coworkers. We heard, how many times did we hear about a newscaster, who was wearing tops but no bottoms, right? There's an ease and a relaxation of professionalism and work norms that has happened as people have migrated out of the physical workplace. And so this first one I want to bring to your attention is from Project Include. It's a nonprofit survey that indicates 25% or 1 in 4 women said that they had experienced an increase in gender-based harassment during the pandemic, with an additional 10% saying that it stayed at the same level, right? So we've got more than a third of women saying it really didn't change, or as a matter of fact, it got worse when people were no longer in the workplace, kind of monitoring and overhearing what people were saying and doing in the workplace. Same project also found that harassment was more likely to be experienced through online and technology-based forms if you identified as Black, Asian, female, or LGBT. Separate survey, similar results done by the Purple Campaign, which is a DC-based nonprofit. Similar results, 25% of employees saying they'd experienced an increase in gender-based harassment since the start of COVID. If you want to get really scary, there was a survey done by Deloitte, which found that more than 50% of women experienced either harassment or that non-inclusive behavior at work as things went remote after COVID. So a few reasons we're seeing the increase according to these studies. One, there's more one-on-one communication, as I said, in isolation, where no one can hear your conversations via Zoom or text or over the phone. And, also, as I mentioned, you've got this blurring of lines between home and work. Employees more casual generally in their manner of interacting, in their dress code, and that's kind of seeped into this issue as well and made it worse. So everybody was remote. Some people are still remote. Some people are coming back to the workforce. Some people never left the workforce. But there has also been issue returning to the workplace. I put Andrew Cuomo's picture just up here based on his criminal indictment several months ago as a reminder too that in the online context, you've got state and federal criminal statutes that could be at play that you need to be aware of that are resulting in very real consequences to our public figures. But regardless, of where you're at, whether you're still remote or whether you're coming back into the workplace, being cognizant of the fact that harassment is still around is something that's important. So we've got compounding issues of increased harassment, whether it's remote work or in-person work. You've undoubtedly also seen the articles over the past 18 months about the toll the pandemic has taken on women, specifically working women outside of work, more home responsibilities, homeschooling, and these studies are showing deep deep dissatisfaction among women in general, spanning, no matter what industry you're in. I'm pointing you to another study that was done by Deloitte recently. 51%, more than half of women surveyed, said they were less optimistic about their work prospects. 35% reported a drop in mental health, 29-point drop in motivation at work compared to before the pandemic. And 59% of women responding to the survey said they're spending more on household tasks, including caring for children. So as a result, this Deloitte survey says 1 in 3 women are considering leaving the workforce or changing jobs. 1 in 3. And that data is from Deloitte and actually a separate study as well. So, you've got overall well-being of women down, and it's down hard. Women are tired, they're unhappy. So what do we think is going to happen, right, in the months to come, folks, as we get to the end of the year and bonuses start to be paid out? Do we think that women are going to leave the workforce? Do we think they're going to be more willing to sue their employers on their way out the door? I think that's a safe bet. So you as employers, already in a tight labor market, looking at multiple valuable pools of talent that might not just be ready to walk out the door, but walk out and slam it. So now is the time, if any, to offer support to your workforces and to start thinking about or brushing up on, ways to avoid harassment claims. And this is going to be the last section of our employment or presentation. I always like to end on a practical note, with some things that you can do to prevent these kinds of harassment claims from happening in the first place. And the first is brush off your policies. You probably haven't looked at them in a couple of years. And that's not just your sex harassment policies, which probably need to be updated, but also your workplace violence policies. A lot of, as we've seen too in studies, domestic abuse really increasing during the pandemic. And as we know, that can sometimes spill into the workplace as well. So good opportunity to dust off your workplace violence policy too. When you're looking at your anti-harassment policies, you want to make sure that you've got examples. You want to make sure that it's described in clear language. Your reporting procedures should be detailed. It should be a male and a female contact person if somebody wants to report that they've been harassed. It should be another option other than the employee's direct supervisor provided. And a couple of other pointers here to include in those policies as you're revising them. A reminder too on investigations, we want to take all complaints seriously. We don't want to ignore things just because they've been happening outside of your earshot. Still consider and investigate sex harassment claims the way that you've always done. It might not look or sound like a complaint, but to the extent that you feel you need to, and it's becoming an issue for your employees, do take your normal steps to investigate to the extent that you can. Training, again, probably something that's fallen by the wayside. We've had other stuff going on, other training that has needed to take place. Time that needs to have been spent on COVID related protocols as opposed to, your run of the mill harassment claims. But this is something that needs to come back to the forefront as people are coming back to work, and as you've now, been briefed on these statistics about harassment not going anywhere, and in some cases getting worse. So train your employees. Your frontline supervisors, I always say, are your first line of defense and your greatest liability. Those are the people who are going to have their ear to the ground. They're going to be the first to know, perhaps, when there's an issue, a morale issue, or issues happening between coworkers. So make sure that they're, your priority as far as getting those supervisors trained. You want to make sure your training materials too are updated. The same old stuff on sex harassment as hopefully you're able to glean at the end of this presentation today. It's not the same as it's always been. So we want to make sure that we've got fresh, current training materials, ideally in-person training as opposed to webinar, because people are just struggling with Zoom exhaustion. Make sure that you are customizing to your workplace, right? If possible, hold up your harassment policy, hold up your discrimination policies, reference them in your training. So that employees know exactly where to look when and if an issue happens in the workplace. And, we want to do training in a holistic way We don't want it to be targeted to, the latest fad that the media is reporting on. So think too about these other kinds of trainings that will build on or supplement or complement sex harassment training, unconscious bias training, leadership training, character training, all things that can bolster the training and build on the training that you're going to be doing as it is. And this is easier said than done. Culture and morale in a workplace is huge. Culture and morale during COVID have taken a hit. People who joined companies, based on the fact that they loved the work environment and have now had that work environment kind of removed from the equation, are struggling a little bit. And so if you're an executive or an upper management level employee listening to this presentation, do what you can to take ownership, to get out in front of the issues. Do surveys. They can be anonymous to employees. You get a lot of great feedback. You can eliminate comments that are on both of the extremes and kind of take a look at what the middle of the road commentary, but culture surveys and really employee surveys in general on a myriad of issues I found to be really, really helpful. And I've made that suggestion to a lot of my clients as we've been working our way through COVID here. And of course, if I get through any presentation on an employment topic without saying consistency, I'm remiss. We always want to be consistent in our practices and the application of our policies across the board, if and when we can, in order to avoid those discrimination and harassment claims. I've been kind of checking the chat function to see if we've got any questions. I kind of blew through that presentation, but I'm happy to take questions now. Otherwise, wish you happy holidays, and hopefully these aren't issues that you'll be experiencing in the new year, but you can prep for and get ahead of as part of your 2022's to-do list. That's anything in the chat function. Give it maybe one more minute.
Wait a little bit, and if not, I can send this presentation out later today, and the recording will also be available on our Ohio Chamber website soon.
Yeah, definitely. If you don't feel comfortable talking about individual solutions, I'm happy to have offline conversations. All right, I see people signing off, so wish everybody happy holidays and be well.
Thank you.